Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Today, we are going to discuss a case of vicarious liability in which the Honorable Supreme Court of India negated that vicarious liability cannot be held on a person in principle if he has entrusted the matter to his junior subordinate. So, when the principal has entrusted the matter to the junior, normally the junior will also be liable, not the owner or not the principal. This is the inference drawn by the Honorable Supreme Court of India. So you all know, once you touch the topic vicarious liability, you must remember the legal principle. Qui facit per alium facit per se. Qui facit per alium facit per se. That means he who does the act through another is deemed to have done the act by himself. This is the legal principle, but it will not apply here in this case. Right? So, two judges bench, Judges Sanjay Kishan Kaul and M.M. Sundaresh, while disposing the case of Dr. V.N. Bora, ex-CEO versus Assam Roller Floor Mills Association Limited. You can see the citation in Live Law 2021 SC 593 in Criminal Appeal number 1967 by 2009, decided on 26/10/2021. They held that merely because the subordinate officer acted in disregard of the High Court or court order, then liability cannot be fastened or fixed on the higher officer. So, in the absence of knowledge, this is more important. If the higher officer does not have the knowledge that the junior officer purposefully avoided to execute the High Court order, then he is not held responsible, only the subordinate officer is held responsible. Right? If you go into the details of the case, actually, while leapfrogging the unnecessary details, let us come to the point. On 3/9/1974, the Assam Agricultural Marketing Produce Act, it provides that according to section 21, the marketing board officers like Bora and others, they can levy tax on the rice purchased, any agricultural product purchased or sold in the notified area. So as you know, all the business people, they will try to get through the loopholes in the act. So they have found out one such loophole. So whenever they are caught, they are saying that they have produced or they have procured the rice or the agricultural product from outside, not in Assam. If it is not in the notified area, they cannot levy any tax on them. Therefore, the tax was lessened. The government did not keep a Nelson's eye over the issue. They have once again brought an amendment in 2006. So, according to section 21A, so if the trader fails to establish the purchase from outside, he has to pay the tax. Basing on this, yes, the agriculture department is used to collect the taxes. Now, these people, Assam Rural Floor Mills, they went to the court and they have established that even though they have purchased the product from outside, these people are collecting levy and tax others. Therefore, the High Court ordered that the amount of levy collected so far, the amount of tax collected, cess collected so far should be returned to them. This is the order of the High Court. But the order was not implemented as the predecessor of Dr. Bora. He was transferred, no doubt he has given instructions, but they have not come into existence in practice. Now, Bora has come there, and therefore, when the contempt was filed, Bora said that it was entrusted to a junior officer. So, the High Court, Assam High Court, observed that there is willful disobedience on the part of both. But how can they say that this man is newly has taken charge? He did not know about the idea orders given by the court. Already his predecessor has entrusted the same to some other person. So even though the High Court fixed the contempt on this man, Bora, and another person, when he challenged the issue before the Supreme Court, Supreme Court has gone into deep the matter and stated that as a principle, vicarious liability. So when I say vicarious principle is responsible for the act done by the agent, but it should not be like that. So here the knowledge of fact is important. So this present CEO does not have knowledge about the issue. Therefore, he cannot be held liable. So this is the decision of the Supreme Court. Please remember, now the Supreme Court has clearly stated that vicarious liability cannot be fixed as a principle on the senior officer in contempt case unless there is absence of knowledge. Thank you very much.